Hello and welcome to News Centre. I'm Ashmit Tej Kumar. Now, the National Company Law Tribunal has reserved its orders on a plea filed by cash-strapped airline Go First. The airline has filed for bankruptcy and is seeking protection under an interim moratorium. Now, aircraft lessors were the first to object, to the petition, arguing that the moratorium will stop third parties from enforcing their contractual rights. Meanwhile, Go First also cancelled flights till 9th of May. Aviation regulator, meanwhile, DGCA, has ordered full refund to all passengers. The CEO of Go First spoke to CNBC-TV18 yesterday and said that bookings have been suspended from the 6th of May to the 15th of May. Go First is blaming its engine supplier, Pratt & Whitney, of defying a Singapore arbitration order. It is suing the engine maker at a US court in Delaware. Well, joining me now to take this discussion ahead is Mukesh Chand, Senior Counsel at Economic Laws Practice, as well as Jagannarayan Padmanabhan, Senior Director at CRISIL, Market Intelligence and Analytics. Gentlemen, thank you so much for joining us. Mr. Chand, let me come to you. The orders have been reserved. What Go Air is clearly seeking is that they want an interim moratorium to protect the airline, to protect the asset. They say the only asset available to them are the aircraft. The objection, however, seems to be that there is no power available with the NCLT. There is no provision under the IBC to grant such a protection at an interim stage, at this stage. Mr. Chand.
Exactly. There is no provision, express provision in the IBC for interim moratorium when application under Section 10 is filed. So, but see, that does not restrict the court for passing orders, interim order, as may be required to meet the situation. Though NCLT may consider passing of some limited order for the purpose of this matter. And a second thing is that ultimately the matter hinges on the admission of the application. If application gets admitted, everything is taken care of, all such issues are taken care of. So NCLT might take a decision to admit the application to instead of passing any interim order on this.
Sure. Mr. Padmanabhan, let me come to you now. One of the concerns that has been red flagged by Go Air as a part of these proceedings are that let's look at Jet, the closest contemporary example of an airline going into bankruptcy. The example they point out is that at the time of going into bankruptcy, Jet had a total of 100 plus aircraft, which whittled down to just 11 by the time the resolution applicant came into the picture. The argument being made by Go Air is that, look, there's an urgent need to protect the aircraft, to keep the lessors from taking back the aircraft, to ensure that the airline remains a going concern. Your thoughts on that?
Absolutely. In fact, we were talking about this yesterday as well in the same place. So that this needs to happen in a very time-bound manner on an urgent basis. Is a given because at the end of the day, you have the passengers. Right now, we are also seeing that till a particular point in time, the tickets being given is suspended. So from a revenue perspective, that has gone down. From a cost perspective, many of that cost is going to come and keep piling on till the point in time a resolution is not there. So from a functioning of the aircraft, it can become a big issue, right? And hence, if a particular situation is not handled here and now, and if the lessors are talking about taking back the aircraft, then what is the airline left with, right? So it is a transportation industry, and transportation is the means at the heart at the end of the day. So that needs to get protected. So all of this has to probably happen in a very speedy manner. For that extent, that whether the law and the applicability of the law, I am not in a position to comment upon it. But if does that happen, right, and that applicability is available, then it should be done on an ASAP basis for
sure. But Mr. Padmanabhan, if I may ask. Right. Mr. Padmanabhan, if I may ask a supplementary question, and this is where, in fact, the counsels for the lessors came into the picture before the NCLT, where they said that this is a malicious piece of litigation. That's what the term that they're using. The language used by lessors is this is malicious, and that this is designed to keep the lessors from enforcing their contractual rights, which is to take back the aircraft, which is to terminate the lease agreement and to take back their aircraft. That's the argument being given by the lessors that, look, this entire piece of litigation is to keep us from enjoying our rights.
No, Ashmit, I think it would be unfair for me to comment on that particular part of it because I am not in privy to a particular two-party deal of what is happening. So I would request that I get excused to that particular question. I may not be able to
Fair
comment
enough.
on that.
Sure, Mr. Padmanabhan. Mr. Chand, if I may come to you, the question that was raised by the NCLT as a part of its today's proceedings is where NCLT pointed out that the main hurdle that has been red flagged by GoAir has been the arbitral award, especially the emergency arbitrator award, which they're trying to enforce in Delaware. The question that the NCLT asked is that what role does an IRP have there? Those are proceedings where perhaps the company and the current management and the promoters are better suited to pursue those proceedings and to secure some kind of relief.
Yeah, but see, that IBC provides that IRP or RP can take assistant of the promoter or director, existing management in running the affairs of the company, so that even if the application is admitted, the role of promoter and management is not totally ruled out. RP can take their assistance in pursuing those actions further to take them to logical end.
Sure. Mr. Padmanabhan, let me come to you now, at least as far as one of the concerns that was raised by the NCLT in these proceedings. The court had raised the question that, look, if the issue that GoAir is facing is that of faulty engines, what is the guarantee going forward that even the existing fleet may not face difficult issues in terms of reliability? Is that something that GoAir will have to contend with, that even though it is the fleet has whittled down to 26, even going forward, even as they apply for bankruptcy, that will continue to weigh on the minds of either the new management or the IRP, that even the existing planes could face difficulty?
Yeah, so to that extent, I think it may not be fair to single out GoAir as an airline because, these engines are being used by multiple airlines, right? So I think that's a larger part of it. A. B, enough checks and balances in terms of from a safety perspective. DGC and others are there in the functioning of the airline, and that is very well documented, and people need to follow that as well. So to that extent, I think GoAir would be in a position to say that, yes, we are following certain set of protocols, which has been very well established, internationally recognized. And to that extent, yes, these 26, aircrafts are found fit to fly. So that's and tomorrow there could be 2 which could get added to this, which could fly, and there could be 2 which could go otherwise. And that is part and parcel of running an airline. So to that extent, to doubt or second guess that the rest of the 26 may also follow the path of what has happened to the others may be a bit unfounded and stretching the argument a bit too far.
Sure. Let's proceed to, of course, you pointed out Pratt & Whitney. They're facing an arbitral award. The company, GoAir, is trying to pursue its remedies in Delaware, trying to seek enforcement of that arbitral award. What is, in your assessment, the best case scenario for GoAir? Is it getting a moratorium from the NCLT, or is it perhaps securing some kind of relief at the arbitration front where Pratt & Whitney decides to comply with the order and starts to supply those geared engines? What is the best case scenario for GoAir that it can hope for from this point on after having filed a Section 10 application?
If that's to me, then a quick one would be that yes.
Yes, Mr. Padmanabhan, for you.
Yeah, sure. So I think the best case for them is nothing like seeing the cash, correct? That the money starts coming in, or an assurance a particular time period in which that this money is going to come through, because then all the creditors and the lessors and everybody else will have that confidence that yes, this will be, it's more a short-term blip which has happened. So I think that's the best case for them to settle this case at the earliest, and more so because of the quantum of the money which is involved in this case. So it's not a small amount of money. It has, in fact, speaks about the functioning of the airline itself. So that will be the first part of it. How quickly are you able to settle this, get the money coming in at the earliest? Maybe it could be through a phased manner, but the money to start flowing in from the through this award part of it.
Sure, of course, that is the honeymoon picture that Go Air will be hoping for. But until that happens, they're pushing for an interim moratorium. Mr. Chand, let me come to you for the final word. It's only in very few cases that we've seen a Section 10 application, and fewer further cases where there has been some kind of interim arrangement allowed in the form of an interim moratorium. Will the NCLT have a difficult time justifying this action if it were to go ahead and grant an interim moratorium in light of limited legal precedents, or does it enjoy the power to go ahead and to allow for this relief even at a point where the lessors, which are essentially the operational creditors, are objecting to it?
No, see, obviously, as you said, that there is no provision IBC for interim moratorium under Section 10 application. But here the question is that you are seeking this moratorium to restrict the party from enforcing their right under a contractual obligation. See, what the moratorium brings in is that the prohibition for enforcement action. You cannot enforce your security. So, from that point of view, NCLT can consider passing a limited order to that extent to restrict enforcement action till the final order is taken, final view is taken on the application company. Because now the thing is that the company has on its own come out that it is now has entered the stage of insolvency. So even the other lenders, other creator will find it difficult not to support this application because except the because they cannot say that the company is viable. Company may be viable, but the status of the company is insolvent as on date because it's not able to meet this financial obligation. So NCLT may have to take a call on admission of the application. But at the same time,
Mr. Chand, thank you so much for joining. Sure, Mr. Chand, that's all the time that we have for him. My apologies for cutting you short there, but that's all the time that we have. That was, of course, our panelists giving us some sense of direction as to where this dispute could go from here. The NCLT orders are awaited. The NCLT has reserved its orders on whether or not to allow Go Air that interim moratorium, that interim protection. So that's a big question mark right now. We'll, of course, begin to get more clarity once the NCLT gives its final orders on that. And on that note, I'd like to thank both of our panelists for joining us and sharing their time and perspective with us. But let's stay with the aviation